Picture this. Prince George standing shoulder to shoulder with his father, Prince William, preparing meals for homeless families at the very shelter where Princess Diana once brought him as a young boy. A full circle moment, right? But that's not the story we're diving into today. Because while that heartwarming scene was unfolding, something far more complicated was happening behind palace doors. Something that would shake the very foundation of the royal family's future. William went completely silent when the document landed in front of him. Not angry. Not defensive. Just quiet. It was a custody filing. Looked ordinary enough on the surface. Just another legal form moving through the system. But people close to the situation, they say it immediately put everything into perspective. All those weird decisions over the past few months. Those hushed meetings. Those carefully crafted public statements that seemed to say everything and nothing at the same time. And now everyone's asking the same question. How does one piece of paper suddenly make the entire family's future feel so fragile? The timing raises eyebrows all by itself. And we're not just talking about private parenting disagreements anymore. This goes way deeper. So settle in, because what we're about to uncover might completely change how you see this whole situation. Let's talk about the part of that document William simply couldn't look past. This didn't start with screaming matches or dramatic interviews or tabloid headlines splashed across every newsstand. It started quietly, with paperwork. Somewhere away from cameras and microphones, Harry put his signature on a custody agreement. The goal: create some stability for his kid's future. Prevent more fighting. Give everyone some breathing room. Sounds reasonable, doesn't it? On paper, it looked like standard procedure, a legal framework, guidelines for parenting, a way to avoid future drama. But here's where it gets interesting. Inside royal legal circles, certain people started reading between the lines, and what they found carried serious weight. This document wasn't just about deciding where Archie and Lilibet would live or how much time they'd spend with each parent. Buried deep in the language was something else entirely. A provision. And this provision acknowledged that safeguarding authorities could step in if welfare concerns were officially raised. That single acknowledgement changed everything. Because once it was written down, it stopped being just Harry and Meghan's business. It created a narrow path. Technical, yes, but very real. A path that allowed institutional oversight to enter the picture. Fast forward a few days. Windsor was already tense when the crisis meeting started. Reports had come in about sudden changes in the children's daily routines. Of senior figures gathered around the table to figure out whether this was just unusual behavior or something legally significant. Among all the folders stacked on that table sat the custody document Harry had signed. But now they weren't looking at it as a family agreement anymore. They were examining it as a He read it once. Then he read it again. And what he saw wasn't his brother trying to make peace. What he saw was a legal trigger. This clause meant that if stability concerns were properly documented, the Crown could take action. Not as a mediator trying to smooth things over, but as a protector. The monarchy wouldn't need anyone's permission. Just solid justification. For what felt like forever, William said nothing. Everyone in that room expected some kind of reaction. Frustration maybe? Disbelief. Instead, there was just this heavy stillness. The kind that settles over a situation when it stops being about emotions and becomes about procedure. The argument between two parents wasn't the main issue anymore. The children were, and that document Harry had signed. It quietly shifted responsibility upward, toward the very institution William would eventually lead. In that silence, everything changed direction. The palace wasn't debating whether to get involved. They were realizing they legally could. And the coming storm wouldn't start with Meghan making accusations or Harry releasing statements, or the press going wild with speculation. It would start with how people interpreted the language. The duty. That one clause written to prevent chaos that actually unlocked authority instead. By the time the meeting wrapped up, William hadn't raised his voice even once. He simply closed the folder, and later everyone would understand. The storm didn't begin with some betrayal or leaked photograph or a child being pulled out of school. It began with a signature. But why did that single signature suddenly matter more than everything that came before it? The next warning sign didn't come from a courtroom or some official press release. It came from a school attendance record, January 31st, morning. Staff at the children's private school in Santa Barbara noticed something small but odd. 2 names missing from the register. No explanation attached. Now, absences happen constantly, especially with high-profile families. But there's a protocol. When travel or relocation is happening, notification is required. This time, nothing arrived, 0 communication. By midday, school administrators reached out through their established liaison channel, the one connected to the UK household structure. Silence. No response from representatives. No word from welfare contacts. Nobody authorized to confirm a change of plans bothered to reply. The children had simply been withdrawn. And here's what worried officials. It wasn't the withdrawal itself. Parents switch schools all the time. What concerned them was the absence of a destination. Note: transfer request had been filed. No spring enrollment paperwork. No academic records being forwarded anywhere. Just a blank space where future plans should have been. The internal message sent that afternoon was direct, immediate concern. Under normal circumstances, a note like that stays administrative, gets filed away, problem solved. But in this case, it crossed into an international framework already outlined in previous custody arrangements. And because Harry's agreement acknowledged safeguarding oversight, a missing stability plan wasn't just a private family choice anymore. It qualified as a reportable welfare irregularity. By evening in London, a quiet alert had reached Windsor. The palace didn't blast out statements, didn't contact the press. Instead, they started verifying facts, attendance patterns, communication logs, scheduled appointments. And a pattern started forming, clear as day. Expected routines had stopped without any explanation. Pediatric visits, cancelled. Education contacts, blocked. Liaison channels, silent. Inside the royal interpretation system, the question evolved. It stopped being about why they moved schools. It became why was every safeguard bypassed. That distinction mattered enormously. A simple relocation could be negotiated, worked through. But a disappearance from the established structure. That triggered protocol. Within hours, the situation was reclassified. Not a disagreement between parents anymore. A safeguarding event. The exact condition referenced in that custody clause, William had read. The agreement's language now intersected with real-world action. The institution had legal standing to ask questions it previously couldn't touch. Meanwhile, across the Atlantic, none of this was visible yet. In California, the absence remained private. But whispers travel faster than paperwork ever could. Parents at the school noticed the sudden departure. Staff conversations leaked beyond faculty circles. By the time British reporters caught wind of a withdrawal without notice, speculation filled every empty space long before any confirmation arrived. Online discussions spiraled out of control. Relocation theories, legal disputes, even rumors of a family split. Without official explanation, every possibility sounded equally plausible. The story became public before anyone even understood what the story actually was. Meanwhile, inside Windsor, the reaction stayed clinical. No emotional language floating around. No accusations being thrown. Just classification. A welfare report had been filed. That meant procedure, not negotiation. The palace's concern wasn't about where the children had physically gone. It was that the entire system designed to track their stability had been completely bypassed. And because the custody document already acknowledged intervention under these exact conditions, the machinery didn't wait for headlines to break. By the time journalists started asking their questions, the response had already moved beyond simple curiosity. For the first time, this stopped being about parenting choices and became about institutional responsibility. A threshold had been crossed, and neither side could easily step back from it once that line was behind them. 2 mornings after that attendance alert crossed the Atlantic, Windsor stopped feeling like a residence and started feeling like a command center. Princess Anne showed up earlier than scheduled. She asked for the full briefing room, not the smaller study normally used for family discussions. When she walked in, she was carrying a red folder. The label read Immediate Review. The kind of labeling reserved for issues that had already moved way beyond simple disagreement. She placed it on the table without saying a word of introduction. Inside were documents gathered overnight. Not speculation, not theories. Records. Hard evidence. First came the medical calendar. Several pediatric appointments had been cancelled in sequence. Each one removed without a replacement date. No forwarding clinic mentioned. No updated physician contact provided. Ordinarily, that might mean travel. But travel requires notice. None had been filed. Next up were the communication logs. The liaison channels between California representatives and royal welfare contacts showed repeated outreach attempts followed by complete silence. Emails acknowledged by delivery systems but never actually answered. Calls redirected to nowhere. Messages blocked entirely. A communication gap deliberate enough to measure and document. Then came the financial papers. This part changed the entire tone in the room. The trust designated for the children's UK education had been disrupted. Its structure altered in a way that removed institutional oversight completely. Funds that were supposed to remain protected within an educational framework were no longer anchored to it. The implication wasn't misuse. It was detachment. Stability mechanisms had been cut loose. Anne didn't dramatize any of it. She simply turned pages and let the pattern form on its own. A routine missing here. A safeguard removed there. Until absence itself became the evidence. William listened without interrupting. By now he already knew about the welfare alert from the school. He already knew Harry had signed a custody agreement acknowledging protective authority if stability concerns were documented. But those 2 elements had remained theoretical until this moment. Legal language just waiting for context. The folder provided that context. Attendance disappearance. Cancelled medical oversight. Communication barriers. Financial structure altered. Individually, each item could probably be explained away. Together, they formed exactly what the agreement defined as a custodial breach condition. For the first time, that clause stopped being abstract. William leaned back slightly. Not in frustration. In recognition. The agreement Harry signed wasn't just about dividing time between parents. It was a contingency framework, one that transferred responsibility upward if routine stability collapsed. And now, step by step, every requirement for that transfer had been met. Nobody in the room raised their voice. The realization didn't need sound. The monarchy no longer had to ask permission to intervene. Legally, they'd been invited to. Anne closed the folder and left it where it rested. A quiet conclusion to the briefing. The issue wasn't about we. Their action might escalate tensions anymore. The paperwork already dictated the next stage. For William, the understanding landed with clarity rather than shock. The crisis wasn't accelerating because of public accusations or media pressure. It was accelerating because the mechanism inside Harry's own document had activated. From that point forward, the question changed completely. Not should the palace step in, but how far the authority now granted required them to go. While Windsor moved through files and clauses, the first countermove came from California lawyers. Meghan's legal team responded quickly once questions about the children's routines surfaced. Their position was straightforward. Parental autonomy. A mother has the right to change schooling, adjust schedules, and manage upbringing without foreign institutional interference. From their perspective, withdrawing Archie and Lilibet from school required no explanation beyond family preference. What appeared unusual to outsiders was simply private parenting being examined under a public microscope. But across the Atlantic, the interpretation was entirely different. Inside royal legal offices, the matter had already moved beyond parenting style. The palace wasn't evaluating whether a decision was wise or unwise. They were evaluating whether established safeguards had been bypassed. And because the custody agreement acknowledged oversight, if stability concerns were documented, the conversation shifted from personal rights to structural responsibility. That distinction created a legal collision. On one side stood American family law emphasizing parental discretion and domestic jurisdiction. On the other stood royal guardianship authority, a framework designed to protect heirs connected to the Crown's institutional continuity. Each system operated legitimately within its own sphere. The complication: the children existed within both at once. Meghan's representatives characterized palace involvement as unnecessary escalation. They described the concern as cultural misunderstanding, a traditional institution misreading modern parenting choices. Requests for explanation felt intrusive in their view, especially when no court in California had declared neglect or danger. Royal advisors saw the same silence differently. Repeated unanswered welfare inquiries, cancelled structured routines, blocked liaison channels. These weren't treated as private matters. They were treated as an absence of verification. Under the protocol William had reviewed, verification mattered more than intention. If stability couldn't be confirmed, intervention was permitted regardless of motive. The debate stopped being emotional and became jurisdictional. Could a sovereign institution exercise safeguarding authority over children residing abroad when a prior agreement acknowledged its role? Lawyers on both sides understood the implications. One precedent would protect personal autonomy. The other would reinforce institutional guardianship across borders. The public watched the disagreement unfold without access to its technical language. What reached them were fragments, brief statements, anonymous sources, carefully worded clarifications. Supporters of Meghan saw overreach, a powerful family inserting itself into private motherhood. Others saw abandonment, a system stepping in where structure had disappeared. The split was immediate and loud. Online discussions hardened into camps. Commentators debated rights versus duty, tradition versus modernity. Every small update amplified interpretation. Silence from one side became proof for the other. Meanwhile, neither legal position softened. California attorneys emphasized that parenting authority begins and ends with the parent unless a domestic court rules otherwise. Royal Council emphasized that the agreement itself allowed protective action once safeguarding triggers appeared. Neither argument depended on public sympathy. Both depended on definitions written long before the dispute existed. By the end of the week, it was clear the conflict wouldn't be resolved through interviews or press statements. It would unfold through procedure, a test of how far one legal system could reach when another claimed priority. The disagreement was no longer a personal feud. It had become a question of whose rules governed the children's future. By the time the third briefing ended, discussion had quietly given way to execution. No public statement announced the change. No spokesperson stepped forward to frame it as a concern. Instead, the palace began activating procedures that existed long before modern press cycles. Rules designed for one purpose only: stabilizing the position of royal minors when guardianship structures became uncertain. The Royal Guardia. Knee ship protocol was opened within the palace. It was described not as punishment but containment. The document allowed the Crown to assume structured oversight when a child's welfare, location consistency, or institutional protection appeared compromised. Once triggered, it moved automatically through pre-written steps. The first measure involved movement. Archie and Lilibet's international travel rights were immediately restricted, now requiring dual authorization from senior royal guardians before any cross-border relocation could occur. It didn't remove parental connection, but it prevented sudden disappearance. The intention was continuity. No abrupt changes of country schooling or legal jurisdiction without oversight. The second measure focused on identity. Under an image protection order, commercial use of the children's names and likenesses was locked down. Branding proposals, media positioning, licensing discussions tied to them were paused indefinitely while legal status was clarified. The palace considered visibility a vulnerability once disputes became public. The order created a protective silence around their identities. Then came the financial layer. The existing education trust framework was restructured so funds returned under institutional guardianship channels. Rather than personal management, expenditures would now pass through designated trustees responsible for schooling, care, and welfare support. The goal wasn't confiscation. It was permanence, ensuring resources followed stability rather than circumstance. Individually, each action looked administrative. Together, they formed something much larger. The Crown assuming operational responsibility without declaring custody in emotional terms. William reviewed the measures one by one. At no point did he frame the situation as a dispute with his brother. Those present later described his tone as procedural, less concerned with fault than with trajectory. The agreement Harry had signed created the legal opening. The welfare evidence activated it. The protocol now defined the response. Supporting it meant accepting a shift in roles. As a brother, intervention could be seen as intrusion. As heir, failing to act could be negligence. The distinction settled the matter quickly. William endorsed the full activation, not as a reaction to personalities, but as adherence to duty. The monarchy, in his view, wasn't entering a family argument. It was enforcing continuity for the next generation tied to its line. The difference mattered inside that room. No one spoke about winning or losing. They spoke about safeguarding, jurisdiction, and permanence. Every measure avoided language of blame, and relied instead on authority already written into institutional practice. Outside the palace walls, speculation was only beginning. But internally, the direction had been set. Negotiations would no longer shape the outcome. Structure would. By the close of the meeting, the protocol was no longer a contingency plan resting in archives. It was an active policy guiding daily decisions. And from that moment forward, events would unfold less like a disagreement and more like a system following instructions already laid down long before anyone involved had been born. William signed off on the final page without adding commentary. Up to this point, the crisis had unfolded in documents, protocols, and competing legal arguments. Then it shifted somewhere far more personal: access. As the guardianship measures took shape, reports emerged that Harry requested time with his children under revised arrangements. The request itself wasn't unusual. What followed was unusual. The response came with conditions: travel restrictions, jurisdiction verification, supervised frameworks. These were now part of the structure surrounding contact. The same procedures meant to stabilize the situation also limited spontaneity. For Harry, the change was stark. What had once been a private family matter now operated through institutional channels. Meetings required authorization. Location mattered. Timing mattered. The process felt less like parenting and more like filling out an application. Inside the palace, this wasn't framed as punishment. It was described as compliance with the safeguards already triggered. Once the protocol activated, individual preferences could no longer override standardized protection. Personal assurances weren't sufficient anymore. Only documented stability counted. Across the Atlantic, however, a different tone surfaced. Sources suggested Meghan's legal team focused on jurisdictional independence, arguing the children's primary residence remained outside the Crown's direct authority. The strategy emphasized resisting recognition of oversight, challenging the reach of royal guardianship beyond UK borders. In simple terms, limit precedent, protect autonomy. Harry's position appeared separate. Rather than contesting every clause, he reportedly pursued mediation, a pathway that might allow contact without escalating legal confrontation. The difference was subtle, but significant. One approach aimed to redefine the framework. The other tried to function within it. Observers began noticing the divergence. Statements attributed to representatives no longer aligned perfectly. Legal language emphasized different priorities depending on the source. Even public messaging shifted in tone. One defensive and jurisdictional, the other conciliatory and access-focused. It didn't confirm separation, but it suggested the strategy was no longer unified. The public read the gap quickly. Discussions moved away from pure custody mechanics toward personal dynamics. Commentators speculated whether the couple still operated as a coordinated team or as two individuals reacting differently to pressure. Each development reinforced the perception of distance. A legal filing here, a mediation request there. Within the palace, interpretation stayed procedural. Officials avoided personal conclusions, noting only that communication routes differed depending on who initiated them. But outside, nuance vanished. The narrative hardened into a familiar shape, not simply a legal conflict, but a relationship strain exposed by crisis. Images and silence amplified the idea. Ere joint responses once appeared, separate ones now surfaced. Where unified messaging had been expected, variations appeared. The contrast wasn't dramatic. No announcement. No confirmation. Just absence of synchronization. And that was enough. The custody issue had begun as a question of authority and welfare structures. It was now being read as something more intimate. Two people navigating the same storm with different maps. For the public, the implication felt unavoidable. If legal strategy diverged, emotional alignment might have as well. Whether accurate or not, perception shaped the conversation. The story was no longer only about who had jurisdiction over the children. It was about whether the crisis had quietly redrawn the lines within the marriage itself. As the legal dispute hardened behind closed doors, The public version of the conflict unfolded somewhere else entirely. In headlines, studio offices, carefully worded statements from California. Entertainment circles began framing the situation as a familiar narrative. Independence versus tradition. Commentators described Meghan as protecting her family's privacy from institutional pressure. Early reports suggested Catits connected to her media partnerships were simply evolving. Supporters argued the scrutiny itself proved why distance from royal oversight was necessary. London reacted differently. The palace didn't issue rebuttals, didn't schedule interviews. Instead, it leaned into absence. A short statement here, a clarified policy there, and long stretches of silence in between. To communication strategists, the approach was unmistakable. Reduce noise, reinforce structure, let actions speak without commentary. But silence rarely stays empty for long. Rumors multiplied. Discussions emerged about potential branding tied to the children. Cooking segments, documentary positioning, legacy storytelling. None confirmed publicly, yet persistent enough to circulate across both British and American media ecosystems. Each report prompted counter-reports. Speculation began feeding itself. Then details started changing online. Archived descriptions were edited. References disappeared from promotional pages. Mentions of the children were quietly removed from project summaries. Observers noticed the pattern immediately. It wasn't loud enough to headline, but it was consistent enough to signal coordination. The children's digital footprint was shrinking,